हेलो एवरीवन। उम्मीद है कि पिछली दो डिक्टेशंस आपने अच्छे से सुना होगा और प्रैक्टिस भी की होगी। कैसा रहा आपका एक्सपीरियंस? कोई दिक्कत आई या सब स्मूथली हो गया? मुझे आपसे एक इम्पोर्टेंट फीडबैक चाहिए। आप किस तरह का डिक्टेशन प्रेफर करते हैं? क्या आपको कोई स्पेसिफिक मैटर चाहिए या मैं रैंडम लीगल डिक्टेशन किसी भी स्पीड पर बोल दिया करूं? और एक और बात, जो मैं डिक्टेशन देता हूं, क्या आप पंक्चुएशन के साथ लिख पा रहे हैं या बिना पंक्चुएशन वाला डिक्टेशन ज़्यादा हेल्पफुल होगा? जो भी आपको बेटर लगे मुझे कमेंट करके बताइए। आखिर में सब कुछ आपकी प्रेफरेंस पर डिपेंड करता है। जो आप चाहेंगे मैं वही फॉर्मेट फॉलो करूँगा। तो अपने सजेशन ज़रूर शेयर करें और कमेंट करके बताएं हमें। तो अगला वीडियो जो होगा वो उसी पर आपकी डिमांड पर ही आएगा। और ये जो डिक्टेशन अभी आने वाला है ये पंक्चुएशन के साथ है। तो अगला वीडियो आपकी डिमांड पर आएगा। सो चलिए मैटर लिखते हैं। गेट रेडी, स्टार्ट। एम्प्लॉयमेंट, regularization, post of tax collector, regularization of service of petitioners denied on ground that they were not in possession of required qualification at the time of entry into service. Petitioners initially engaged as tube well operator within bracket pump driver and not as tax collector in 2002 2001. Engagement of petitioners was a backdoor entry. They did not possess required qualification at the time of entry in service, not in dispute. No reason to interfere with the order denying regularization of service. Appeal dismissed. Stop para. Order on CM exemption application number 1 of 2020. Colon para. Munisivar Nath Bhandari and Rohit Ranjan Agrawal, JJ, the application seeking exemption from filing certified copies of the orders of the tribunal is allowed. Stop para. The defect stands cured. Stop para. Let a regular number be given to this appeal. Stop para. Order on CM delay condonation application number 2 of 2020 colon para. An application has been filed for condonation of delay in filing this appeal. Stop para. For addressing the other application, we like to consider the merit of the case. Stop para. Order on memo of appeal colon para. By this appeal, a challenge is made to the judgment dated 1/11/2019 passed by the learned single judge dismissing the writ petition preferred by the appellants. Stop para. It is the case, where the appellants challenged the orders dated 3/3/2017 and 8/3/2017 in a writ petition for denying regularization of service. Stop. The writ petition was dismissed not only in reference to the judgments of this court in the case of State of UP and others versus Chidhi and another, 2015 within bracket 9 ADJ 218 colon 2015 within bracket 6 AWC 6167, but for the reasons that the petitioners were lacking the requisite qualification as on the date of first engagement. Stop para. Learned Counsel submitted that the appellants were in possession of required qualification at the time of entering into service in the year 2000/2001 on the post of tax collector, but ignoring the aforesaid, the regularization has been denied in reference to the instructions framed by the respondents in the year 2001. Stop. The petitioner's case was covered by the rules of 2016, but taking it to be in consonance to the instruction of year 2001, the claim for regularization of service was denied. Stop. The judgment referred by learned single judge is not applicable to the facts of this case. Stop. The prayer is thus made to cause interference in the impugned judgment and direct the respondents for regularization of service of the appellant in reference to the rules of 2016. Stop. Para. We have considered the rival submissions of the parties and perused the record. Stop para. A perusal of the order impugned before the learned single judge shows denial of regularization for the reasons that petitioners were not in possession of the required qualification at the time of entry into service. Stop. The appellant's petitioners were in fact, engaged on the post of tube well operator within bracket pump driver and not as tax collector somewhere in the year 2000/2001. Stop para. We do not want to comment on the manner in which the petitioners were engaged, otherwise, it was a backdoor entry. Stop. The observation aforesaid many, however, be not taken adverse for any purpose as it has been made, taking note of the fact given in the impugned order challenged before the learned single judge. Stop. The fact further remains that the writ petition was not dismissed only in reference to the judgment referred therein, but for want of qualification of the post. Stop. Once was to be in possession of required qualification at the time of entry into service, if seek regularization. Stop. Appellants petitioners entered into service in the year 2000/2001 and documents relating to qualification have been submitted, but petitioners have failed to refer to the relevant rules to show that they were in possession of required qualification. Stop. It is more so when dismissal of the writ petition is not only in reference to the judgment referred therein, but for want of required qualification. Stop. Thus, it was necessary for the petitioners appellants to address the issue aforesaid while challenging the judgment. Stop.